Hello and welcome back to Beach House 34. You are listening to the Avery trial, the Stephen Avery trial, and this is episode 6. Before we jump into today's testimony, I want to give you a really quick recap of the previous episode, episode 5. If you haven't heard that one, I will be sure to link to it above if you're watching this on YouTube, and I will also add it to the show's description. I also want to make a note that if you are watching or if you haven't yet seen it on YouTube, I do show all of the exhibits that I actually have access to. The channel is youtube.com/beachhouse34. If you are a Patreon member, you get early access to all of these recordings for just $5 a month. And you get this access a full week before the general public. For more information, visit patreon.com/beachhouse34. So here's what happened last time in episode 5. Before the jury even walked in the door, the prosecutor, Ken Kratz, had this issue with the defense attorneys and wanted to bring it up with the judge. And what he did is he tried to call out Stephen Avery's lawyers for hinting that someone else might have killed Teresa Halbach. But the judge basically told him, oh, and he did this, by the way. He's like, hey, I just didn't like what they said in their opening statements. So after he said this, the judge said, hey, relax. They didn't break any rules. And then when the witness gets on the stand, this is Angela Schuster. This was Teresa's boss at AutoTrader. And she explained how the photo shoots worked when Teresa went out to all of these different properties. She talked about what those hustle shots were, ones that she'd do on her own for more money, and so forth. But the big takeaway from that episode was that Teresa often made stops that AutoTrader wouldn't have even known about until she had turned in her paperwork the next day. So bottom line is, the state wants you to believe that Teresa never left the Averys, or at least the Avery salvage yard. But the defense is pretty much saying, what if she did? In today's episode, we're going to hear from Dawn Pliska. She worked at AutoTrader too. She's actually the one who took Stephen Avery's booking for that October 31st appointment, the same day that Teresa went missing. So let's see what she has to say. So Dawn Pliska is called into the room to the stand, and the clerk has her raise her hand, calls her as a witness, asks her to spell her last name, which she does. And then at this point, there is no jury in the room. They are questioning her about some things outside of the jury. And it's begun by the prosecutor, Ken Kratz. Miss Pliska, this is not your testimony before the court, but this is, before the jury, but this is simply retrieving from you some very narrow information about a conversation that you had with Teresa. Do you understand that? Yes. You were a receptionist with AutoTrader during the fall of 2005. Is that right? Yes. And what kind of relationship did you have with Teresa? In other words, did you and Miss Halbach have occasion to discuss matters of a more personal nature? Yes, we did. During the course of those discussions, did Miss Halbach ever describe for you a contact or incident that she had with the defendant, Stephen Avery? Yes. Could you describe, first of all, the words that she used, and then we will describe the circumstances surrounding that. So first, tell us what she told you. After she was out there around October 10th, it was like about a week or so after that, she had stated to me that he had come out in a towel. He meaning whom? Stephen Avery. Had come out where? She didn't specify. She just said that he had come out just in a towel. All right. Did Miss Halbach describe for you anything else about that? Any other details about seeing Mr. Avery in a towel? I just said, really? And she said, yeah. And she said, yeah. And she laughed and just said kind of, ew, Okay. You said kind of what? Ew. Ew? Yeah. Just that. I guess not in a positive way. No, not in a positive way. No. Did Miss Halbach Or was she seeming to describe a specific event? In other words, was she remembering that event when she was describing it for you? Yes. At this point, Attorney Kratz says, at least as far as my offer of proof, the rest is argument. I don't have anything further from Miss Pliska for this offer of proof. And the court then says, Mr. Strang, so one of Stephen's attorneys. And then his cross-examination begins. And again, not in front of the jury. And he continues and he says, hi, do you think this was a week or more after October 10th? Yes, that I talked to her. I don't know when the incident exactly was. Okay, but you're probably talking to Teresa Halbach October 17th or sometime shortly after that? Yes. She did not say that this had happened on October 10th or any specific date. She did not specify the date. No. She didn't call you to tell you about this incident? Not specifically. No, it just came up in conversation. You were chitty-chatting with her? Yeah. And the reaction was, ew? Yeah, it was unfavorable. Yeah. And then she sort of laughed it off? Right. This was 15 seconds of conversation? I would say, yes. How long was the phone call, roughly? Altogether, probably a couple of minutes at that time. What sorts of other subjects did you two cover in that conversation? Probably just work-related. I don't really remember all the details of the conversation. I just remember saying that. Do you remember whether she called you or you called her? I think that time she called me. Probably she had a question on one of her photos, I think. Okay. So she had some more immediate work purpose for the call. Yes. And the two of you got sort of chatting, and this is one of the things that she brought up? Right. She did not give you any sense of time on when this had occurred? No, she did not. Attorney Strang then says, okay, thanks. That's all I have. And Kratz then says, Judge, one follow-up. And a redirect is then done. In the interim, that is between October 10th and October 17th, or really around that period of time, would you have these kinds of conversations often with Teresa in a personal chit-chatty conversations? Pretty much every time she called in. I talked to her a couple of times a week because I sent out the photo leads and everything, so we talked quite a bit. Attorney Kratz says, that's all I have. If we could excuse Miss Pliska, Judge, then I'm prepared to make my argument. And the court says, all right, I just have a couple of follow-up questions. And the examination is then done by the court. You said the conversation took place a week or so after October 10th? Yes. And is it your understanding that October 10th is the day that she was describing that this happened? I really can't say for sure. All right. So you don't know if she was talking about a visit to Mr. Avery's property on October 10th or at some previous unspecified visit? Yeah, I would not know that for sure. And do you remember how the comment, or what prompted the comment, what background conversation led up to it? I don't really remember. No, I just remember we used to talk about different things that had happened during our day that were unusual or funny or different customers and things like that. So the court says, all right, you are excused from the courtroom for a few minutes, Mr. Kratz. And then Attorney Kratz says, thank you, Judge. As this court knows, this statement is being offered pursuant to the hearsay exception of a statement of a recent perception. It is important, Judge, to note the different admissibility standards for recent perception compared to present sense impression, or even excited utterance, where time is important, that being time, the time-sensitive nature. Because of the nature of this particular conversation, it's clear that the three factors that are required for a recent perception have been established. First of all, the issue of whether or not the event or condition that's being described was recently perceived is a factor, but recently is in a much, much broader term. 1988 Court of Appeals decision of Kluver versus Evangelical Reformed Congregation, cited at 143 Wisconsin 2D 806, was a 8 to 10 week period between the event and its description. The recent perception admissibility theory was satisfied by that 8 to 10 week period. But here, Judge, I think we can infer that because it only occurred a short time after the October 10th meeting, that it was of recent perception, at least more recent or recent enough to satisfy that particular prong. Again, Judge, the statement, or secondly, I should say, the statement must be made where the declarant is recalling something clearly and that it's not in response to some litigation or investigation. The second and third prongs aren't really, I believe, at issue in this case. So I believe the state has met, through this offer of proof, the foundation under 908.045(2) with the declarant, that is, Ms. Halbach, being unavailable, that this is a statement of recent perception and would ask the court to allow its admissibility. Okay, let's bring this down to regular speak, okay, or just somewhat coherent speak. Essentially, what Kratz is trying to do here is to get the judge to let something in that Teresa had said before she died, because she obviously cannot testify, right? Normally, that would be hearsay, which means someone repeating what someone else had said out of court, and that's not usually allowed because you can't cross-examine someone who's passed. But there are special exceptions, and one of those is called a recent perception. That basically means if someone makes a statement about something that they personally saw or experienced around the time it happened, and they're not making it up later for a lawsuit or trial, then you can sometimes get that statement in. And Kratz's point is that the rules for this are a little flexible. It doesn't have to be seconds or minutes after it happened. In past cases, courts have allowed stuff people said even 8 to 10 weeks later. So here he's saying, look, what Teresa said happened shortly after that October 10th meeting. That's close enough. Plus, she's passed on, so she can't testify. But what she said back then should still count. So in a nutshell, he's telling the judge, we followed the rules. This statement should be fair game. So to me, and if you've listened up to this point, I definitely have a bias against Kratz, not my favorite person. But I kind of wondered, I thought, gosh, this really sounds awful lengthy and flowery and everything else. And so I researched this and I thought, is this just normal? Is this just really what happens in a courtroom? And it's technically normal lawyer language, but evidently it's also textbook Ken Kratz. Evidently he's got a history of layering his words to sound super formal and authoritative. But half of the time it's just the words that he says is just unnecessary. In regular courtrooms, prosecutors do have to lay out legal foundations, like, explaining what hearsay exception they're using and why. But a clear, normal version would be, Your Honor, we believe this qualifies as a recent perception because it was made soon after the event. It was about something that the witness saw directly or heard directly, and it wasn't done for the lawsuit. Period. Done. Okay? But Kratz loves to drop citations, old case names, and these layered sayings. Like, quote, the admissibility theory was satisfied by an 8 to 10 week period, blah, blah, blah. So he sounds extra credible to the judge and makes the defense look like they're challenging some kind of settled law. And yeah, it can come off as if he's trying to sound smarter than he actually is. So he really could say this more clear. He just chooses not to. Okay, so let's get back to now the defense's response to this. And this is Attorney Strang. Thank you, Your Honor. I agree that if this statement fits anywhere, it would fit under Section 908.045(2). Wisconsin's unusual, I think not taken directly from a uniform rules of evidence or model rules of evidence, but Wisconsin's exception for statements of recent perception. Clear out the underbrush first. If there's no gainsay in the fact that Teresa Halbach is unavailable, so the state meets that threshold requirement. And I, like Mr. Kratz, view this statement as not in contemplation of litigation. I have no reason to question Teresa Halbach's recollection being clear at the time. And this statement was not in response to instigation of a person who was investigating or litigating a claim. So the question does come down to the recency requirement. Going to back up just a little bit, if you think about the basic rationales of hearsay exceptions, most of them are either because the out-of-court statement is of a type that's extraordinarily reliable, and courts have recognized that over the last several centuries, or that the hearsay statement is of a type where we have a high necessity to have something like that. And of course, reliability and necessity are not poles. All of the exceptions, at least where unavailability are concerned, have both a necessity component and then some assurances of reliability. And because we're under the unavailability exceptions, the necessity interest presumably would be higher. And that's why we see a relaxation of the reliability requirement with a little bit more expansive tolerance for a period of time than, for example, under the excited utterance exception, where there's a lower presumptive necessity, showing because the availability of the declarant doesn't matter. So with that focus, let's look first at necessity. Very, very low necessity here. The state originally sought this type of evidence because it had added a sexual assault allegation to the information. That now has been dismissed, so sexual assault is not in play. And the state conceded in its opening statement that it can't answer the motive question, can't explain for a jury why, and won't attempt to prove motive here. So even where sexual assaults go into play, the original reasons the state offered in pursuing this bit of evidence, originally as uncharged misconduct, both have fallen away, and necessity is very low. Reliability, though, also is quite low here. As my question suggested, and I think the court's question cemented, we have no way of knowing here whether this statement related back as far as June 20th or as recently as October 10th, which itself would have been about a week or perhaps more after the incident. Mr. Kratz cited Kluver, Kluever, versus Evangelical Reformed Emmanuel Congregation. And it's true that there was an 8 to 10 week period of time at issue in Kluver. But the facts of Kluver are worth noting. The statement was made while the declarant was in a hospital bed recovering from a bad fall. And the court noted in accepting the 8 to 10 week time period that the statement was one of his few islets, ISLETS, of memory in the time period since his fall. So there was sort of a compression, or at least an amorphous quality of time for the declarant there, kind of a foreshortening, if you will, of recency given the injuries that that man had sustained and was recovering from in the hospital bed. So I don't know in the end that Kluver gives a whole lot of help here. I do concede that we don't need the immediacy or quite the recency that an excited utterance would require for the reasons I explained concerning the underlying rationale for these hearsay exceptions. But I don't think the state has shown that this had any real recency. It certainly wasn't the purpose of the call. No sense of immediacy, casual chit-chat, at least a week and perhaps 4 months after the incident at issue. So coupled with a very low necessity for this at this point and a dubious showing of recency, whether we look to just 908.0452 or the court also considers the 904.03 analysis, again, with the necessity and how probative really is this of any relevant or material issue. I think for both those reasons, this just ought not be admitted. There is some prejudice to it too. It's got a little bit of a salacious quality. I'm not saying it couldn't be dealt with on cross, but I don't think the state has met the threshold to fit it within this hearsay exception. The state has offered no other, and on balance, I also think that 904.03 would suggest exclusion. So let's decipher what Strang is saying. Okay, I'm going to make this one really short and sweet. Strang's whole point is, sure, this might technically squeak in under the rules, but it's not actually necessary anymore. It's not really fresh. It's a little too gossipy. The whole, hey, he was out there in a towel. How about that? Little too gossipy to be fair to Stephen. So let's just leave it out and then move on. And once he's done, Mr. Kratz then has his own response to this. And Kratz says, just very briefly, Judge, the uniqueness of this statement, that is, the event of a man of Mr. Avery's stature, showing up or coming out, as the term is, in just a towel, we can infer would have drawn some comment if it would have happened sooner, perhaps as early as June 20th, as counsel may have suggested. But I think the fact that this was in the course of business chit-chat, and this statement comes out of the blue, if you will, as far as Mr. Avery goes, adds to its reliability and to its credibility. And for those reasons, Judge, and for the other reasons that I have mentioned, we'll ask the court allow this as admissible. And then the court gives their opinion and says, all right, I'm going to take a few minutes to check a few things. I will be back probably within about 10 minutes with a decision. At this point, a recess is taken. The jury is still not present. And then the judge comes back and says, the court has previously ruled that the statement regarding the brief statement of Teresa Halbach that Mr. Avery had come out in a towel could be admissible subject to appropriate foundation. The appropriate hearsay exception reads in relevant part as follows. The following statements are not excluded. The statement which describes an event or condition recently perceived by the declarant, not in contemplation of pending or anticipated litigation, and while the declarant's recollection was clear. In this case, it's not disputed that the statement was not made in contemplation of any litigation. There does not seem to be a dispute that the statement was made while the declarant's recollection was clear. There is an issue as to whether or not the statement described an event or condition recently perceived. The situation is complicated somewhat in this case by the fact that, as the court understands the testimony of the witness, we don't know precisely when the date was that the statement was alleged to have been made. In the court's opinion, this is a very close decision. As the parties recognize, the recency requirement does not, in this case, necessarily mean a day or two before. But the court feels that some specificity is required. And in this case, we don't really know within the range of weeks or months exactly when the statement was made. Presumably, it could have been, or when the observation was made, presumably it could have been anytime from the middle of June until October 10th. I'm also concerned by the lack of context in which the decision was made, or it's a very short one-sentence description of an event or condition without any qualifiers or any solid explanation. And in the court's opinion, that makes its relevance and certainly potential for prejudice, relevance less, potential for prejudice greater. And for that reason, while the decision is admittedly a close one, the court is not going to allow the evidence in for the reasons I gave. The lack of specificity and the uncertainty as to exactly when the statement was made, and the fact that different inferences could be drawn from it because there is so little information about its background. Anything else before we bring the jury back in? And Attorney Kratz says no, and the court says, very well, bring in the jury. Okay, so what did the judge actually say? In plain English, he basically said, look, this little comment about Stephen, being in this towel might technically fit a hearsay exception, but it's way too vague. They don't know exactly the date that Teresa was referring to when she talked about this. There wasn't any real context around it, like why this happened, why she was there, what date, all the details. So it's just a single unclear sentence that could make Stephen look bad without adding any real value. So bottom line, it's too fuzzy, it's too risky, and the jury is not going to hear it. So let's get on with the testimony. And at this point, they then call back in Dawn Pliska, but this time the jury is there, and she is now there to testify in front of the jury. The clerk again has her raise her hand, and she is called as a witness and again spells her last name. And the direct examination is begun by Ken Kratz. Ms. Pliska, I want to direct your attention to the fall of 2005 and ask if you can tell the jury how you were employed at that time. I was a receptionist at AutoTrader. And what were your duties as a receptionist? I sent out the photography leads. I took incoming phone calls, sent out T-shirts, mailed out catalogs. As part of that employment, did you have the privilege of knowing a young woman named Teresa Halbach? Yes, I did. Could you tell the jury, please, how you knew Miss Halbach? She was one of our photographers. She started just a little after I did, so we were fairly close. Ms. Pliska, I'm going to direct your attention specifically to October 31st of 2005. Ask if you were working on that day. Yes, I was. Do you remember about what time you started work? I started at 7. 7 in the morning? Yes. At or about 8:12 a.m., do you recall receiving a call that day? Yes, I do. And could you tell the jury about that call, please? It was from a man. He said that he wanted the photographer who had been out there before. He was selling a minivan and he needed her to take photos. Did this man identify what name the photography job would be under? I couldn't quite make him out because he was very hard to understand. The closest I got was the initial B, Janda. This man said that he wanted the photographer who had been out there before. Did he identify by name that person? No, he did not. Did he provide you an address where he wanted this photo to be taken? Yes, he did. Do you remember what that was? I don't remember the exact number, but it was something B. Avery Road. If I showed you a document from that morning, would that help refresh your recollection of that? Yes. Attorney Kratz then says, Exhibit 17. Janet, do you have that? And then Attorney Kratz continues his questioning. I have now handed you what has been marked for identification as Exhibit number 17. Tell the jury, first of all, what is that? This is a photo shoot lead. It's for a same-day appointment, which we don't normally do. But if the photographer is able to, we could have written them up and sent them to them. Whose handwriting is on that form? That's mine. Would that form have been filled out at the same time that you received this call from this person? It was actually filled out later on after I had left a message for Teresa to see if she could make it out there that day. But does that sheet help refresh your recollection as to the information provided by this man? Yes. What was the address that was given for the photo shoot? 12930A Avery Road. Now, when this man said that let me start again. Remind me of the language, the specific language the man used in requesting the photographer. He had wanted the photographer that had been out there before. Did he say why he wanted that same photographer? Because he had a minivan for sale. Was a phone number provided? Yes, it was. Could you tell us what that phone number was, please? It is 920- and I'm going to redact the rest of that. Now, did you know the district or the area from whom this call had come? In other words, what photographer you were going to assign to do this shoot? Yes. How did you know that? They were assigned by location. When you would type it in the system, it would automatically pop up the photographer's next available date. Who was the photographer that had that district? Teresa Halbach. I think that you had said that same-day appointments were unusual. Is that right? Yes. Can you tell the jury about that, please? Normally, we had a 24-hour notice for photos, but sometimes if someone wanted to make a deadline and the photographer was in the area, we would leave a message for them, and then they would go out to that person's residence if they could make it. Ms. Pliska, I am now going to direct your attention to approximately 9:46 a.m. and ask if you tried to call Teresa Halbach at that time. Yes, I did. Could you tell the jury about that call, please? I wasn't able to get a hold of her, so I left her a message saying that someone said, that she had been out there before. I couldn't find a record of him in the system, but if she could make it today, that would be fine. Otherwise, I had scheduled it for the following Monday, which would have been her next available appointment. Were you notified, Miss Pliska, any time later that day that Miss Halbach was able to make that appointment? When I came back from lunch, there was a note from Angie Schuster that it was said that she had wanted me to fill out one of these lead sheets and fax it to her because she would be able to make it that same day. She meaning Miss Halbach? Miss Halbach, yes. Finally, Miss Pliska, were you able to, and did you, in fact, speak with Teresa Halbach later that day? Yes, she called me at 2:27, and we talked. Who? Teresa called me at 2:27, and we talked for a little while, and she said, yeah, I'm able to go get that photo. By the way, it was the Avery brothers, and I'm on my way out there right now. So 2:27 p.m. She told you she was on her way to the Avery property? Yes. Let me ask you this, Miss Pliska. How do you remember that call? I remember because I looked at the time, because she didn't normally work, I think past 1 o'clock. And I thought it was kind of late for her to be going out there. So I happened to look at the clock at that time. So, all right. Just as an aside, do you remember what else you guys talked about at that time? She needed UPS labels, and then I was telling her about my son going trick-or-treating. So you remember that being Halloween? Yes. Finally, Miss Pliska, after that call, after you hung up and concluded that call with Teresa, did you ever have occasion to talk with her again? We tried to get a hold of her on, I think, Thursday morning, but we weren't able to. Let me ask that again. Did you ever talk to Teresa Halbach again after that time? No, I did not. Attorney Kratz then says, I would move the admission of Exhibit 17, Judge, and that's all the questions I have for this witness. And the court says, any objection to the exhibit? Attorney Buting says no objection, and the court says Exhibit 17 is admitted. Who will be doing cross? And Attorney Buting, again, one of the attorneys for Stephen, says, I will, Judge. The court says, Mr. Buting, and he begins. Good morning. Good morning. Is it Miss Pliska? Pliska. Pliska. Okay. Judge, could you maybe explain to the jury that it's your request that we wear these mics when we move around? And the court then says, that's right. The attorneys who stand, we require the attorneys to use these mics so everybody can hear. And Attorney Buting continues, so forgive me if I fumble with them a little bit. And then his questioning begins. All right. Now, you still have Exhibit 17 up in front of you, do you not? Yes. All right. Now, I will refer to that in just a minute. But you mentioned that your duties are answering incoming phone calls? Yes. Calling out to photographers and assignments? Yes. Also faxing out these appointment sheets? You actually prepare them sometimes yourself too? Yes. And how many photographers? And you work in the Hales Corners office, right? I'm no longer employed there. I'm sorry, back in October of 2005. Yes. Will you wait till I finish the question so that the reporter is not tripping over us here? October of 2005, you worked in Hales Corners. Yes. And how many photographers did you deal with at that time around the state? Probably around 6. Okay. And most of your communication with them was by email or fax or phone? Mostly by fax and phone. Mostly fax and phone. Okay. Yes. In fact, did you ever meet Teresa Halbach? No, I did not. You never met her face to face at all? No. So your relationship with her, when you say you were close, it was just from phone conversations? From phone conversations, yes. And these phone conversations were usually just a couple of minutes or so, because you had other duties, other calls coming in and all of that? Yes. Okay. So you didn't really know much personally about her other than what would be transmitted in these very brief phone calls? Yes. All right. Now, this phone call that you got on October 31st, you knew the name. You recognized the name Janda, Janda, right? That's what I could make out, okay, from what he had said. And in fact, you know then, the man gave you the address, and it was on Avery Road, right? Yes. And you knew that the Jandas and the Averys were basically the same people, same area, right? No, I did not. You didn't? No. Were you interviewed by an investigator Wiegert of the Calumet County Sheriff's Department about this incident? I'm not sure. I believe so. Okay. Let's say at about 8 or 9 on November 3rd, that would be Thursday. Do you remember getting a call from an investigator at the Sheriff's Department? Yes. 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 And he asked you some questions of what you knew about this phone call on the 31st of October? Yes. And did you tell him that you knew that the Jandas are basically the Avery brothers? That they have done work for them before, but does not know why they gave the name B. Janda. Did you tell him that? No, I did not. So if he wrote that in his report, was he just making it up? I did not know that it was, Teresa told me it was the Avery brothers. At the time I took the call, I had no idea who it was. Okay. Exhibit 17 in front of you there has an account number, right? Yes. That's the Avery's account, isn't it? I believe that was one that I had just created for this lead. So you created this as a whole new account? And because I couldn't find it in the records, I checked by phone number and the last name, and I couldn't find the person in there or him in there. I'm going to show you Exhibit 19. See if maybe this refreshes your recollection a little bit. Is that one of the appointment sheets that you or somebody in your office prepares and faxes to the photographers? Yes. And at the very, very top, there's a little code that says run by. Yes. And it says D.Pliszk. That would be you, right? Yes. So you actually ran this report yourself. Yes. In this particular instance, September 19th, 2005, right? Yes. And the very first name listed there is Tom Janda, is it not? Yes, it is. And the address there, would you read that off, please? I'm sorry, I can't see. I'm sorry. 12930A Avery Road. Is that the same address that you have here on Exhibit 17, the photo shoot that you filled out on October 31st? Yes. So on October 31st, you did in fact know, or those were records, that you had taken an appointment for the Jandas on a prior date. That's not necessarily from me. There were 3 or 4 of us that would run appointment photos. It would depend. I ran the reports in the morning. I didn't necessarily read them thoroughly. I would just fax them out to the photographer. If you would look at the screen right there, I'm showing you a zoomed in picture of this Exhibit 19. The date is September 19th of 2005, right? Yes. And it does indicate that you ran that. I ran the report, but that does not mean that I had taken the original lead. Sure, but you ran the report, and the report included Tom Janda, the very first one, very same phone number, very same address that you have in front of you on the October 31st exhibit, correct? No, the phone number is different. All right, but the address is the same? Yes, but I didn't search by address in the system. You just searched by phone? Right, because we had tried to get people off the phone as quickly as possible. So if I couldn't find it by phone number and last name, and for some reason it didn't come up in the system. For some reason, but it should have, because you did have a record of Jandas, correct? From what that is, yes. Okay. And I realize it's been a long time, so you may not remember everything as well 15 months later, but the record speaks for itself. Attorney Kratz then says, I'm going to object to this. It's argumentative. It says Tom Janda, not B Janda, not the phone number. She's answered this. It's argumentative. And the court says, I don't know if it's argumentative, but the last thing the attorney said was a statement, not a question. Attorney Buting then says, I will move on, Judge. Sorry. And then he continues. Now, you said that the same day appointments that would be called in were unusual? Yes. Not that unusual, though. They happened, right? Yes, they did. You have a form that's made for that purpose? Or for reshoots, if someone had already had a photo, the same. So particularly repeat customers who knew the photographer's route, knew what day they would be in the area, those are the kind of people that would call the same day. They knew they could still get in before the deadline. Sometimes people just weren't aware of the deadlines and they would see. We could have also ran it for a week without a photo and just extended his ad as well. Okay. So when you got this phone call, though, that morning, there was nothing that unusual about it, about getting this call from this gentleman saying he wanted a photograph taken of the car. Was there? No. Okay. And you just followed your regular routine, which is to call, in this case, Teresa, leave a message with the name, address, see if she was available, right? I left the name and the phone number and the addresses. Yeah. If she could make it, that would be great. If not, we could always call the customer back and he was scheduled for the next week after. And that's something that she had done before, right? Yes. You had done same day ones with her, right? Yes. And in your experience, it also would not be unusual that the person calling may not be the person who actually owned and selling the vehicle, right? Yes. In fact, that very day, October 31st, there was a gentleman that called in, left the name Sipple, I believe. Does that ring a bell? No, it does not. Well, you sent out, let me do this. Let me mark this as an exhibit, and exhibit number 20 is then marked for identification. And he continues. Can you identify exhibit 20 for us, please? This is one of the leads that would have printed because it was done before 24 hours. That would have been one of her normally scheduled leads for the day of the 31st. Okay. And that was run by you? Yes. Once again, exhibit number 21 then is marked for identification. And could you exhibit or identify exhibit 21 also, please? This is also another lead. It appears to be the 29th of October. And at the very top there is a fax date and time. Do you see that? Yes. What is it? It says 10/31/2005 0093. And excuse me, this is in the transcript. It's noted that this is wrong in the transcript. And then the questioning continues. So like 12:13 a.m.? Yes, this appears, I think this is from Teresa because it says rescheduled for Monday. Right. The handwriting. Let me just put these up on the screen for a minute so we know what we're talking about. Exhibit 20 is the report that you did, that you ran at 7:08 a.m. on Monday, October 31st, right? Yes. And that's what you would have then faxed to Teresa for her schedule for the day, right? Yes. And that only has one appointment on it, a Mr. George Zipperer, right? Yes. But in fact, you knew she had more than one appointment on that day, right? Yes. And exhibit number 21, which I'm showing you now, is the report that you indicated she faxed on October 31st at 0013 hours, right? Yes. And on that, this is actually an appointment scheduled for a previous day, Saturday the 29th, I think, right? Yes. And on that, she wrote another appointment that was to be rescheduled for Monday, right? Yes. And the name of that individual, can you read? I don't know if you can read the first name, but the last name is Sipple, right? Yes. So I have one other one I want to show you. I haven't marked this yet, but maybe you can tell me from looking at this. Do you know what kind of form this is? This is the actual lead form that prints along with their schedule. So this is something that you prepare? Yes, or I edit it. And then he says, I better mark this. Actually, exhibit number 22 is then marked for identification. And this is exhibit 22? Yes, this was the one I had originally done. And I believed I changed it for the Monday, the same day appointment for the 31st. I was originally going to schedule it for the following week. Okay, but what's the difference between exhibit 22 and exhibit 17? That wouldn't print until the next day. This one here, exhibit 22, would not have printed until Tuesday. Okay, because that's why we usually don't do same day appointments, because they don't print until the following day. Okay, so by print, you mean enter the information in your computer and do what? You fax within. That's not what you fax to the photographers usually, is it? Yes, it is. It is, yes. Okay. They got that actually as well, too. So they could put information on there pertaining to the ad and then photo number and everything so it would match up. Okay. And this specifically is for B. Janda, right? Yes. Is that the address? 12930A Avery Road? Yes. It's got phone numbers over there on the right, correct? Yes. Even got information about the vehicle. 1989 Dodge minivan? Yes. And that is to be, what is it? Run till sold. What does that mean? The ad will run as long as the person needs to, as long as they would have called every 3 weeks to renew it. Okay. So all of this information was given to you by the caller on October 31st at 8:12 a.m., right? Yes, it was. Now, did you know that you did know that Mr. Avery had Teresa's direct phone number, right? No, I did not. Were you aware that he had done a privately arranged shoot with her on October 10th? I wasn't. Those are called hustle shots, and I didn't have any information about those, so I wouldn't have known. Well, let me show you a couple more exhibits. Exhibits number 23 and 24 are now marked for identification. I'm showing you exhibit 23. Can you identify that, please? It's one of her lead sheets, and it looks like it has, I think that's her writing on there. This is when she was done with photos. Right. She would fax them in so she could get paid for them. Sure, I understand. And this one also was prepared by you? Yes. Okay. And the date of this one is 10/10/2005. Okay. And what this does is this lists, well, let me put it up on the screen once and we'll talk about what it says. Can you also identify exhibit 24? This appears to be one of the logs that the photographers did on their own, like a hustle shot or maybe a call in or something that they would have written up themselves. So this is Teresa's writing. That looks like Teresa's writing? That looks like Teresa's writing. Yeah. And can you tell what date this is at, all or where it came from, or if it's in any way associated with Exhibit 23? I really can't be certain. Okay. Well, let me put them up on the bigger screen and we'll talk about them from there, please. All right. First, Exhibit 23. Let's see here. This is the exhibit you mentioned you prepared on October 10th, right? Yes. It's a little bit hard to see there, but there you go, October 10th. And this was a list of Teresa's scheduled appointments that had been made through AutoTrader on that day, right? Yes. And there are just 3. Actually, it looks to me like the second one is crossed off. It's a Robert Beaudry. Yes. The first one is Robert Beaudry. The second one is Roger Pugel or something like that. Yes. But Mr. Avery is not on here, correct? He was not a scheduled appointment that day? No, he was not. Yet down below, she has written Steve Avery, right? Yes. And done next to it, right? Right. And in fact, in your records, you are aware that there's actually a photograph that she took on that date of a Pontiac Grand Prix from Mr. Avery. Are you aware of that? I wasn't certain of the vehicle. I did know she had an appointment on the 10th, but I wasn't sure of what the vehicle was. Okay. So that was an appointment that Mr. Avery apparently arranged privately with her rather than through your office, correct? It appears to be, yes. And the hustle shot document that you are referring to, let me zoom out first so the jury can see. These are forms that the photographers have that they fill out or they may fill out if they are doing hustle shots. Yes. Privately arranged shots, right? Yes. In fact, it says at the top, private party, photo log, right? Yes. I'm sorry, a little hard to see. And in this, she has got Steve Avery's name. Yes. You recognize this to be her handwriting? Yes. Because you have seen it many times. And then she also says Steve Avery, $45 paid cash, right? That looks like the account number 45800. Oh, okay. That's the account number. I'm sorry. Just says paid cash? Right. And it lists the 1984 Pontiac Grand Prix T-tops and Oldsmobile engine 5.0 make offer, and it has got a phone number, right? Yes. So would it be fair to say then that the records show Mr. Avery must have had some phone number for Teresa in order to make this private arrangement with her on that date? Attorney Kratz then says, objection, speculative, judge. And the court says, I'm going to sustain the objection. And Attorney Buting says, all right, and then continues. This is an example of these hustle shots that are made privately between the photographer and the customer, right? Yes. And you know that that does happen frequently with photographers, correct? Yes, it does. And that it did happen with Teresa. Yes. In fact, more than just this one time we mentioned with Mr. Avery, there were many hustle shots she did, correct? Yes. And when she would do those, you would have no way of knowing that she had gone to one of these private party hustle shots until she faxed back the report at the end of the day. Isn't that right? Yes. And unfortunately, though, on October 31st, you never got a form back that said where she had gone, right? No. So you don't know whether or not Teresa had any hustle shots, privately arranged shots on October 31st, do you? No, I do not. And this phone conversation that you had with her at 2:27 p.m., you had some brief discussion, and she said that she was on her way to the Averys? Yes, she did. She said the Avery brothers. Is that what she said? She said the Avery brothers. Yes. She seemed very familiar with them? Yes, she did. You don't know whether she meant she was on her way directly or whether she intended to make another stop before she got there? No, I do not. I just assumed. She said she was on her way there right now, so I assumed. Okay, so if she was not there for another hour, you don't know whether she would have made another stop, got a bite to eat, something like that? No, I would not. Or if she had another hustle shot in between? No, I would not. More importantly, you don't know whether after Mr. Avery, Teresa had a private hustle shot where she was going, where she was planning to go to. Do you? She didn't mention it, but no, I did not. And she wasn't in the habit of mentioning when her hustle shots were with you, right? Sometimes she would, sometimes she wouldn't. So, okay. Now, these hustle shots, by the way, sometimes they would be where she would go to a customer for one car and she would hustle a second one while she's there, right? Yes. And in fact, that happened in this Tom Janda case where she got two photos on the same date, September 19th, right? I'm not certain. All right. Well, that was something that happened, and those were considered hustle shots too, right? Yes. So you don't know whether somebody hailed her as she was leaving Stephen Avery's residence, somebody else on the Avery salvage property, a brother, customer, whatever, who hailed her and said, hey, let's take a picture, private hustle shot of another vehicle. Do you? Attorney Kratz then says, Judge, objection. That does call for speculation. And Attorney Strang, at this point, says, my question was, she doesn't know. I'm trying to establish. And the court says, the objection is overruled. And then Attorney Buting continues, is that correct? I would not know. All right. Now, just a couple of one other point that I want to make here. Since it appears that Mr. Avery had made a private hustle arrangement with Teresa Halbach in the past, you don't know of any reason why he couldn't have also done that on October 31st, do you? Unless he would have lost her phone number? No. Okay. And of course, if he was going to do that, put it this way, if he had wanted to kill Teresa Halbach, he could have simply called her directly instead of calling your office and leaving a red trail. Easy trail right to his house, couldn't he? Yes. Attorney Buting says, thank you. I have nothing further. The court says, Mr. Kratz, any other questions? And Attorney Kratz says, no. The court then says, very well, you are excused. And then, members of the jury, that takes us to noon. So we'll take our lunch break at this time and resume at 1 o'clock. So the jury leaves and the court then addresses the attorneys. And he says, all right. Counsel, are there going to be any other outside the presence of the jury matters to address this afternoon that you are aware of? Attorney Buting says, no, Judge. Attorney Kratz says, not that I can think of. And Attorney Buting then says, I would and I should have. I move the admission of all those exhibits that I referred to, which are, looks like 20, 21, 22, 23, 24. And Attorney Kratz says, well, 24, she said she couldn't identify, so we'll object to that. Doesn't seem that he posted it to the jury when she said she couldn't identify it, but it should not be received. It was not identified. And Attorney Buting then says she did identify it as Teresa's handwriting. She identified it as a private party log that's used in their business. The only thing she couldn't identify was the date. But that will be linked up by the prior witness who testified that on October 10th, 2005, a photograph was taken of that very car that's listed there. And the court says, Mr. Kratz, and Attorney Buting continues, which is Exhibit 16. Attorney Kratz then says, I don't object to the relevance and that it appears to link up, but she couldn't identify it. And the court says, I think she identified some elements of it. The date she couldn't identify, but that's by the nature of the exhibit. Though actually, I think the date's repeated again a little higher where it's easier to see. At any rate, I'm going to move all of the exhibits. Attorney Kratz then says, thank you. And the court says, see you at 1 o'clock. All right, let's break this down to what the hell we just heard, because this was a lot of phone records, a lot of appointment forms, and a lot of, did she, didn't she kind of talk. Today, the big witness was Dawn Pliska. She was the receptionist at AutoTrader, and she's the one who actually took Stephen Avery's booking for October 31st, the day that Teresa Halbach disappeared. So what did Dawn tell us? Basically, she got a phone call at 8:12 that morning from a man. She said that he was hard to understand, who then asked for the photographer who had been out there before. The name that he gave was a B. Janda and an address on Avery Road. So Dawn fills out this appointment form, leaves Teresa a message, and later got confirmation back that Teresa would fit it in that same day. Teresa then called Dawn back around 2:27 p.m. and said that she was on her way to the Avery brothers. That's Dawn's words. After that, nobody at AutoTrader ever heard from Teresa again. So why does this matter? Well, it really comes down to the timeline and whether Teresa could have gone anywhere else after that. The defense got into this. Dawn admitted that same-day appointments, they were unusual, but they definitely weren't unheard of, especially for repeat customers like Stephen Avery. Teresa also did what they called hustle shots, these little side gigs that she arranged privately for extra cash. Dawn admitted that she wouldn't have a clue if Teresa had squeezed in another stop before or after Avery's place, because they only found out about these hustle shots after the photographer had turned in their paperwork, which obviously never happened. So the big takeaway from Dawn's testimony was that she confirmed that Avery's appointment was legitimate. It was called in that morning. It wasn't out of the ordinary. And Teresa was still alive and on her way there at 2:27 p.m. But after that, it's just this huge question mark. Did she leave? Did she do another stop? Nobody knows for sure. So once again, the state wants the jury to believe that Teresa went there and period, that was the end. The defense wants you to see the cracks. There was wiggle room. There were gaps. Could someone else have crossed her path after she left Avery's yard? We don't know. But what this witness made clear was that it was very possible. And that's where we kind of leave it for now. In the next episode, we're going to hear from Curtis Drum. He was a pilot out of the Manitowoc Airport who flew the aerial search for Teresa's car on November 4th. And he'll walk us through what he saw or what he didn't see. And if we have time, we'll hear from Stephen Schmitz. This is another AutoTrader customer who Teresa also visited on the same day, October 31st, that she had gone to the Averys. Did he see anything? Did he notice anything odd, or was it just a normal stop? Before we wrap this episode up, though, I want to give you a huge thank you. Thank you for listening and sticking with this trial read. There is so much to take in, and there is so much more to come. I appreciate you more than you know. If you're just jumping in, now is really a great time to catch up. You will find the link for the first episode in the show's description, show notes, etc. And also a really, really quick heads up that I forgot to mention in the last episode. As this trial continues, we're going to start to get into some exhibits that can be a little tough to look at. Some are graphic, some are disturbing. I'm going to be blurring anything that's too questionable on YouTube because YouTube has certain community guidelines that I've got to abide by. But if you want full access to every exhibit, including the unedited versions, you will find those on Patreon. And again, the link for that for Patreon is in the show notes / description. It's only $5 a month. You get early access to all of these episodes and all of the trial exhibits that I actually have access to. All right. Until next time, take care. I will see you back here for the next episode, episode 7. We will talk soon. Bye for now.